Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about debt collector lawsuits, third-party debt collection lawsuits. They are, I always, some of the times when I make these types of videos about debt collector lawsuits, I'll say that debt collector lawsuits are at an all-time high, like from a video in the past. And then I'll look at the numbers again, and it's like at an all-time new high. So debt collector lawsuits, third-party debt collector lawsuits are at a new all-time high. And one of the things that I am seeing that I did not see before is that these third-party debt collectors are suing people for smaller amounts. When I first got into the business, debt collectors would go after people. They would actually take people to court over $500, $800. You know, the amounts were low. I mean, they were doing it for the higher amounts too, but it was a lot of small amount lawsuits they were going after people with. And then I saw that they were most lawsuits were like $1,500 and up over the last few years. Like I rarely saw any that were at that lower number. And now I'm starting to see debt collector lawsuits coming in at those lower amounts. And I'm like, that is crazy. And then another thing is that I'm seeing certain communities that are like the lawsuits have just risen. Like if you live in certain area codes in certain states, they are like just slamming hard with virtual lawsuits where they're just submitting the documents and then they're able to go on a Zoom and do the lawsuit that way rather than having to have an attorney in that area. All they have to do is be licensed in that area. Like the rules have kind of gotten a little bit wide open because of what happened with COVID. Debt collectors, just like we as people figured out, kind of different ways to live. Some people didn't go back to work the same way, working at home, or they're doing different types of freelance work. Debt collectors also saw that there was an opening that they didn't have to pay the additional fee to have an attorney in that area do the lawsuit, that they could actually file the documents and do everything by Zoom. So it was like a lot of different ways of doing debt collector lawsuits had changed due to what we went through with COVID. But also with the internet, with information, with people like myself who are actually helping people beat debt collectors in these lawsuits, is that we started seeing success. And then they started to make adjustments because they were like, hey, people, we are used to winning these lawsuits. And these are companies that are like, some of them are publicly traded companies. And here's the deal with a publicly traded company. Let me give you a quick lesson. Is that they have to make money. Like you always wonder why they'll have these, like on CNBC, and they'll be like, a company made good money, but it seemed like it's just not enough. Like they got to make even more money. Like you can have good profits, but it has to be more profits because their stocks will either stagnate or go down because they want to see the numbers consistently go up. Well, with the disruption that we put into the market by helping people understand what debt collectors have to prove when they're trying to sue you in court, it disrupted that pipeline of easy default judgments. Because if you just have a small percentage of people fight for their rights, a small percentage of people who understand what I'm about to teach you right here, it disrupts their flow of business. And you see where they start to make adjustments, and they actually are trying to go after people either harder by making, by not just saying, okay, we're going to dismiss the case. We want to make you have to come to court again and submit more information about why you believe we should not win this case, even though you would just submit the same information because the case is weak based off of what you provided. You're the one, the debt collector is the one that's providing the information to build a case against people. And if they don't have all the appropriate documentation, if they have all of their stuff out of order, it's not the person's fault, it's their fault, because when they bought the debt, they assumed that responsibility. So I'm going to show you what you need to watch out for. And it does take some reading. It does take some building a story together for when you present it in court. Because if you just have it all in a mess, you're going to end up losing. Like I've had some comments on YouTube where a person stated I did everything that I was supposed to do. I don't know if they went off of my information. I don't know. I know that they wasn't a client where we put it in order, but they said I submitted everything I did. And I'm probably one of the things that biggest mistakes I see a lot of people make when they're fighting against debt collectors is that they deny everything. And if you go into court denying everything, you're basically just setting a trap for yourself. Because why would you have to deny everything when it's their burden to prove everything? So all you have to do is you just have to lay out from the information that they provide, lay out a story in your affirmative defense to counteract everything that they provided. And that would also stop you from getting into this back and forth, because what they'll start doing is they'll start quoting other cases. And they'll say, well, in this case, the judge said that this was enough. And then you have to go and try to do some footwork and some research and then insert that in. And you're not an attorney, and we're not attorneys. So why would we get into that back and forth with that when we could just say the documents that they provided do not prove their case? And now you might be saying, well, they're giving statements, they're giving, they got that they purchased a debt, all of that stuff. That's fine and good. But there still is a burden that they have to prove. And we've helped people win major cases that were against them, $20,000, $30,000, $40,000, because of the information that I'm about to show you here on how you could beat third-party debt collector lawsuits. So let me take a quick drink here. So when responding to debt collector lawsuits, this is not in any specific order, but I'm just telling you, you need to get your notes. You need to get your notepad out and you need to take notes, because I'm telling you how you can beat them. Some people say sometimes I don't tell people how they can, the specifics about what to look for or what to do. This, I'm going to make sure, even though I think I do it in those videos, I'm going to make sure. And I think that the reason why people miss it is because they don't take notes. Or just, you take notes and rewatch the video. Sometimes I'll say just rewatch the video. You got to take notes and rewatch the video, because when you rewatch the video, you will hear it in a different way. Because the first time you're listening to my video or watching the video is that you're actually learning something new. And then the next time you've learned that new thing, now you can pay attention to what you need to do with that new thing regarding these debt collector lawsuits. So first thing is, you want to check to make sure that the debt collector followed all of the rules according to the Fair Debt Collection Practices Act. There are some things that they have to follow with giving you the opportunity, giving you the, sending that letter to you, that first communication, giving you the right to dispute any or all of that debt. That is a right. And that first demand letter that they send you is just a demand letter. It has nothing to do specifically with you paying the debt, even though they kind of put two things together in there. It's really just a letter to allow you to dispute any or all of that debt. That's basically what it's for. So we want to see, number one, did you get that letter? Because if you didn't get that letter, that is part of your affirmative defense. So according to the Fair Debt Collection Practices Act, debt collectors, when they purchase a debt, must send you a demand letter. That demand letter cannot be sent from another third party. That demand letter has to be sent directly from their company. They cannot disclose your private information to any third party. So when we are putting together our response to beat debt collectors in a lawsuit, is that we want to look at everything that they're supposed to have followed according to the Fair Debt Collection Practices Act. Now, it is very easy for them to overcome this because they're going to identify who the original creditor was, identify themselves, identify the amount, have a couple of statements. That's basic, like bottom line stuff that's in the the Fair Debt Collection Practices Act. That's just like bottom line stuff. They're going to be able to really give you that information, and it's up to you to accept it or not accept it. And that's why you have the ability to do a dispute. If they did not give you that opportunity, you need to write that in your affirmative defense, because that is a requirement, and that can get your case dismissed. The next thing is the assignment of debt rules. So they're going to, they'll play this game where they'll say it was purchase, assign, assume, all of that stuff. It does not matter. What the bottom line is that they're the ones who's saying that they own the debt and that they are the ones that's going to come after you for that debt. Now, this is when they send that summons to you in the, when you get your summons, it's going to be served to you. And then you're going to look at who is assigned that debt. Like what is the company? And then it's going to show in that assignment, it's going to have a proof of purchase from that original creditor. And you need to look at that proof of purchase from the original creditor. And I want you to pay attention to some things. Pay attention to these things. They're right in there. You might have missed them. A lot of people don't even pay attention to those because they just look at the word proof of purchase and they're saying, well, okay, the original creditor sold the debt to the debt collector. So they, and some of the times they might even say assigned or something in there. And they use those terms to try to bridge over certain issues with having the debt. Like some of the times they'll say assigned because they're trying to trick the court by saying that it was assigned so they can avoid some of the issues that might be with them having that debt. So like, let me give you an example. If an original creditor has a debt collection company collect for them, that would be an assignment of the debt. That would be an assignment. So what they'll try to do, and I'm going to get into how this is so tricky, because I'm going to show you how they're actually using the assignment from other debt collection companies, but they want the court to think of the original creditor. Like I'm going to tell you what we saw in documents. So the original creditor, what they're going to do is they're going to have some information inside of that proof of purchase. Or that purchase contract. And they're going to talk about the accuracy, guarantees, assumption responsibilities. And I'm going to get on this one last. I'm going to talk about these here real quick. So you'll notice that they do not make any guarantee of the accuracy of the accounts. Like some of the times people are amazed when I show them, hey, do you see what it says here with the original creditor? They say that they do not guarantee the accounts. You'd be like, well, they just got them from them. They're the ones that have the stuff. This is the thing, is that if you pay attention, that statement does not have your name on it. It's just for the bulk of all the accounts. So you ever heard of if you got a spoiled apple in the barrel, it could ruin the whole barrel of apples? Well, if you have spoiled accounts in there, and you're not identifying which accounts, and the original creditor is not guaranteeing the accuracy of all of the accounts, and they're the ones who actually do the accounting for the accounts, how could the debt collector just say, okay, the original creditor is not guaranteeing those accounts, which they're not even identifying, but your account is accurate. Everything in your account is accurate. So now I hope that you're getting to see where we're going with this and how we're getting to that right there by using their own documents. Pay attention. We're getting to that by using their own documents against them, which they don't want you to pay attention to that. So also you'll see that it says that they assume all responsibility. So if any account has any issue, if someone filed bankruptcy and they sold that account and that debt collector tries to sue someone and that person had filed bankruptcy, They can't go to the original creditor and cry to them and say, you sold us that account that had a bankruptcy on there. And we broke the rules by contacting that individual. You know, the trustee is trying to go after us or fine us. And they can't go back and cry about that. They assume all responsibility. So if that potential thing could happen, which it does happen from time to time with debt collectors, where they contact someone and that was in the matrix of a bankruptcy, but they didn't know. And the reason why they didn't know is because all they do is they get a file with a whole bunch of names on there, a whole bunch of last 4 digits of an account number, and a couple of statements and an amount, and they assume all responsibility. Now, another thing that I want you to pay attention to is that we see this on some of the contracts coming from credit card companies, is that it will actually state that they cannot sell that portfolio to anyone else except for back to the original creditor. It's not on all of them, but I want you to make sure you scan your documents. It's very important that you scan them and you read it again and you read it again. And actually, this is something, if you're watching this video right now, this is something that I've never revealed. I can say this, I've never revealed this on any videos. I've never revealed it. So I hope that you appreciate it. If you're watching right now, you need to like this video, because I've never revealed that information on any videos that I talked about with dealing with debt collector lawsuits. But it will actually state in the sale document from the original creditor that they cannot sell that. So, and I'm going to get into where you could start to see where that contradiction is coming up with the debt collectors, because debt collectors use portfolio companies to buy the debt, and then they will distribute it out to either their own regional debt collection firm, like Resurgent Capital does with LVNV, or LVNV does it in the reverse with Resurgent. It just depends on what region you live in. So the next thing that we want to pay attention to, so we got this here. We know what we're doing with all of this, with the proof of purchase, what we're looking for. These are the things, how we're just taking our notes and we're saying, okay, no guarantees. We're going to build up our affirmative defense based on this stuff. The next thing here is the proof of contract with the debt collection company. Let's see what they come up with a proof of contract. Obviously, they're going to say that they purchased the debt, but you still want to mention that in there, because that's going to be something that they don't want you to even bring up in your response. It's like, show me the proof of contract with you, and then we're going to talk about this privacy notice issue right here. So give me your proof of contract with the third-party debt collector, and then we're going to talk about how you are able to have access to my private information. We want to ask that question. Show us either and remember when I talked about that assignment, how they tried to make that work with that assignment, where they're going to it's like they're trying to fool the court. Well, if it's assigned from the original creditor has the privacy policy, and then we're collecting this for the original creditor. But they're not collecting it for the original creditor. They're collecting it because they bought the debt. But they don't want you to ask that question. So we're looking at what they're going to come back with this privacy notice. From the responses that we've gotten from debt collectors who decided to dismiss their case, is that they never answer that question. Like, and there's more things that they have to overcome, but we've never gotten an answer to this, like a logical answer to the question about give us a privacy notice. They'll always come back with another question on, like, why do you want us to give you information about how we got access to your private information? Because they don't want to answer that question, because they know that they're using that assignment as a bridge. They're using that assignment as a bridge. Okay, now the next thing is we want to get the balance, payment, interest rates, credits, and signature and PIN codes authorizing all of the charges. Someone had asked me on YouTube, they said, well, why do I need the PIN codes and the signature and all of that? Let's reverse that question. If you are dealing with, let's just say you're dealing with the original creditor, and the original creditor is saying you had all of these charges, and you knew that all of these charges were not yours, that some of them are, some of them aren't. What would be the first thing that even the original creditor and you would want to look at? Is where did those charges come from? And then was there a PIN code used for those charges? Was there a signature used for those charges? Was the card present when you did those charges? We're using their own thing, their own information against them. They're just coming with an amount. All they're doing is they're coming to you with an amount that they're saying you owe. And it's like, okay, well, let's prove. And please pay attention. What am I not doing? Because I get a lot of people who do this, and there's other websites out there that are, giving people documents and information on how to fight back against debt collector lawsuits. And it's like, why would you tell them to deny everything? Why would you tell people to deny everything? You're walking in the court, they have a contract, they have some stuff to substantiate to have you in court. But when you're denying everything, it's like, well, is your case built on denial, or is your case built on challenging the documents that is being presented against you, making them prove their case, rather than it's not me, this ain't me, I deny this, that, most people, most other websites, all the other videos, all they basically do is try to say proof of contract. Well, if it was that easy to just say proof of contract, why are millions and really billions of dollars collected every year from people getting sued, and all of them are not default judgments? A lot of people walk into court denying everything, and they get a judgment against them. So you want them to prove all of this information, and here's an important reason on this. Some people say, well, why on the interest rate? Why? We have shown, and even the CFPB and the FTC have shown, where either payday lenders or certain types of loan companies were either charging the interest rate that was not legal, which is crazy, but that have actually shown that the interest rates were not legal. We had a client who had a payday loan, and because they reset that loan, so they got an initial payday loan and they reset that payday loan in that 30-day period, that means that they got charged an interest rate when they originally got it, and when they reset that loan, they put what they had on the other loan on top of that reset, and then they put a new interest rate on top of that, which made the interest rate that they charged for the 30 days illegal for their state. That was in Missouri, actually. He won that case. So you want to check that out. This is about checking out what they give you. And now they're not going to give you all of this here. You have to request that. You have to make them have to prove that by the documents, because all they're going to do is they're going to give you a couple of statements, or maybe, I've even seen it now, they're trying to give more statements. They're trying to put a lot more pressure on the original creditor to get more statements. But still, they have to overcome that claimed amount. So they have to prove from day one, which is what you would actually be able to do with the original creditor, is to prove that entire amount that they owe, that they're claiming that you owe. And you want to get your signatures and your PIN codes, any credits that you had. Maybe they're going to, usually with this, they'll say, well, what are you disputing? Well, I'm not with the original creditor anymore. I'm with you, and I want to look at all the records, and then I'll let you know what I was disputing. You have a right to get that. They're supposed to have all the documents. They assume all the responsibility. And then your balances and your payments. That you want all of that stuff. Now, the next thing that you want to look at is the proper service. Did they serve you properly? But also in your state, did they, per the laws in your state, did they properly serve you? Because in some states, it's very lax on service. They have to just go there one time and then they can mail it. Some states allow them to go there and just lay it, ring the doorbell, and then they can tie it to the door or however they're doing it. Or they can mail it to you, or that, it's crazy. State to state. Again, that's what happened with COVID, is that it allowed debt collectors to be able to have a little bit more leeway on suing people in court. So you need to check to see if you have proper service. You can actually get a debt collection lawsuit that you have lost in a default judgment solely based on improper service. We've been able to help clients get that reopened. And also, just to go ahead and bring this up, I was going to bring it up later. If you have already lost your lawsuit and you did not respond to it properly, and like you didn't go through what I'm teaching you right here, you can ask to have it reopened. And but you got to look at the rules. In my state of Wisconsin, we have a 6-month rule. Some states it might be a little bit shorter. Some states it could be a little bit longer. I know in most states, if you can bring up the improper service, that is one way that you can get it reopened. And also one of the things that they're going to be looking for, if they allow you to reopen, is they're going to say, well, what is the information that you would be presenting that would give you a chance of winning? Because some of the times they don't want to get the courts back. They're trying to keep some dates open for new stuff that's coming down rather than old stuff that was already dealt with. And if they feel that it's not going to change the outcome, then they might not let it reopen. So that's why you need to have this information, because you will be able to challenge them. Your new information is to challenge them with the stuff that I'm teaching you here. So another thing is that you want them to give you the full, this is where I start saying alleged, the full alleged account number. Most of the time they're going to give you the last 4 digits, and you want them to give you that complete account number. This is going to be very difficult for them to be able to overcome, but we have seen where debt collectors have stepped up their game and they started making the original creditors give them the full account number. The next thing is the chain of custody. Now, with the chain of custody, this could be very tricky, because what they'll do is if they buy it and then they sell it, like I'll use Resurgent and LVNV funding for this example. What we'll see is Resurgent will buy the debt, LVNV would sue for the debt. So Resurgent buys the portfolio, sells it over to LVNV. But this is the crazy thing when I talk about how they try to fool the court. We've actually seen where Resurgent bought the debt, LVNV funding got the debt from Resurgent, and LVNV funding is suing for the debt. But to make it look better for the court, they produce their documents and they're out of order. So it'll say, in one document, it says original creditor to Resurgent, Resurgent to LVNV, and the dates will be in order. But then also they'll have another document thrown in there, because what they have to do is they have to have some sort of statement from LVNV funding's lawyers that they've actually reviewed the case. And what we'll see is that because they were rushing, because they're all really the same company, they're not different, it's just a different LLC, is that they will have the LVNV funding dated before the Resurgent date or at the same date. And they're like, well, okay, wait, hold on. So you sold it, you bought it, sold it to LVNV funding on the same date. But on other documents, you don't show that you sold it to them on that date. That's why you got to read through those documents. Like, we'll see this. One of the times on there we saw where it was Sherman Acquisition. I know you've probably heard of that debt collection company. Sherman, Resurgent, LVNV funding, and then a letter showing LVNV funding owning the debt before Resurgent owned the debt, but they have documents on one of their sale documents where it was Sherman, Resurgent, LVNV in that order. So that's why you got to pay attention to that chain of custody. Just read it, slow it down, and look at it. And then you got to look at the other documents that they submitted. And you could look at the dates and be like, these dates do not coincide with each other. Because if they're saying that they own it and then they owned it on this date, so that's another way of using their own documents against them. And we see that a lot, especially with Resurgent and LVNV funding. And then and that gets into this right here is when you're looking at that, you want to ensure that they even really have the ownership. Because if it's all out of order, if it's truly out of order, which we do see that, if it's truly out of order, are they truly the owner of the debt? Because, there's documents that you'll see that are in their conformity, the bill of sale, some other stuff from the original creditor. You'll see all of these documents that they'll put in there. They'll have one stating that one of the reps with the debt collection company reviewed the file and it's according to the business records, even though that document is not a document from the original creditor. So they cannot talk about the true accounting of another company that they're not part of, but they'll put that letter in there. And you need to look at what the date is on that letter, because what we see them do, because it goes again towards what I talked about earlier in the video with dealing with third-party debt collectors, is that they never expected people to get educated and to actually be able to fight back against them. They were just used to putting all of these documents together, submitting them to the court, and the court just saying, okay, it's good to go. You lose, or if they don't come in, it's a default judgment. So these are the things that you got to watch out for. It takes a little bit of time, but you got to watch out for them. And again, we do offer a service where we can help you with this. We would like to review it first before we can let you know what we can or cannot do. The other thing here I want to mention here, right here, we're also seeing a huge problem with people losing their or not actually losing, but their court cases being extended based off of this. Now, not to say I'm not telling you to make this decision. That's totally up to you. But a lot of people have, it's a big thing about making debt collectors pay. Like, I'm going to make them pay. If I win, I'm going to make them pay. You can have all of this information and any of this could have got your case dismissed. But we're starting to see some people who did use some of these other websites and they're adding this counterclaim request inside of their affirmative defense, where they what at the end where you get to put what you would like to have, and they're putting a counterclaim, and that is actually extending the case where it could have got dismissed. The reason why it's extending it is because the debt collectors don't want to get put on record that if they fail to do all of this and they're going to be paying out for whatever dollar figure you put on there, they don't want to have that put on record. Now, some people may agree with me or disagree. I think that if you have a 5 or 10 or 1,000, whatever the amount the lawsuit is, and you can get it dismissed with prejudice, that you've already got your counterclaim, because you don't have that debt collector, and that debt will not come back to haunt you anymore. So I think that's, we've always told people you did win. If they did not, if they didn't get the judgment against you, you did win. There's no, you might want to do things, there's some people who have that in their mind that they want to make them pay. If they, you're going to pay for bringing this debt collection lawsuit to me even though I did have that with the original creditor, but I've figured out this way with this information to be able to beat you because you bought it for pennies on the dollar and I have no responsibility to pay you. But your payoff is that everything is gone. That's what I tell people to do. Don't get greedy in this situation. Let's just say, hey, I owed you, like I'll give you an example. Gentleman owed $28,000. That's right on my website. Or if you're on my list, you've gotten an email where he, $28,000 totally dismissed. Now, if he would have put a counterclaim in there, I guarantee you that they would not have dismissed that case, even though they did not have this information. There were several issues with that, and it was actually for a truck. It wasn't even a simple credit card debt. This was actually for a semi-truck that he ended up, giving that back. It got repoed, and they came after him for $28,000. So by simply putting a counterclaim in his suit would have extended it and possibly got it into a situation where the judge see it another time and say, hey, I just believe that you got to pay this $28,000. But the way that we do it is that the debt collector is like, I don't want to leave this up to the judge. We just choose to go ahead and have this dismissed. Even though some of the time the judges just say, hey, you didn't prove everything, I'm going to dismiss it. But most of the time, when you put this up against them, the debt collector ends up dismissing the case. And that's where you want to be at, because it could be a situation where they just send you a letter to you and to the court and say, this case is dismissed. Nobody has to show up. Not going to waste anybody's time. It's just done and over with. All right. If you need help with third-party debt collection lawsuits, there's a link below this video or above this video. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, your3scores.com. Grab your TransUnion, Equifax, Experian credit reports, all 3 scores, all of the information that you're going to need on to either be able to fight debt collectors or to repair your credit. Something else that came to mind on your credit reports when you are dealing with debt collector lawsuits, look on your credit reports to see if it has the word canceled on there. Because if it says canceled on there, that debt could actually have been canceled in 1099-C. And if you have debt collectors coming after you, grab my 3-pack of letters, statute of limitations letter for debt that's past the legal statute of limitations to collect, cease and desist collection activities letter, and debt validation letter. Use the one that is appropriate for your specific situation. I put the instructions on there. I do ask for a donation on those. It could literally save you time, money, frustration. It can stop debt collectors in their track. They don't even expect you to respond this way. Remember, I talked about it earlier with that demand letter. They don't expect you to respond this way to their demand letter. Thank you for your time. Please subscribe to the channel. Like this video. Post your questions and comments. It's Stephen A. Williams, president and founder of thecreditrepairshop.com.